Most Americans have heard the phrase, "You have the right to remain silent." But very few people know where those words actually came from, or why they exist in the first place. They didn't come from a movie script or a police manual. They came from a real interrogation room, involving a real man who didn't know his rights, and a legal system that assumed silence meant guilt. That man was Ernesto Miranda. In 1963, Miranda was arrested in Phoenix, Arizona, in connection with a kidnapping and rape investigation. The police brought him into custody and questioned him for about 2 hours. By the end of that interrogation, Miranda confessed. The confession was written down, signed, and later presented in court as the central piece of evidence against him. There was just one problem. Miranda was never told that he had the right to remain silent. He was never told that anything he said could be used against him in court. He was never told that he had the right to consult a lawyer before speaking to police. At the time, that was not legally required in many states. The system operated on an assumption that if someone talked, it was voluntary, and if they stayed silent, it was suspicious. Miranda was convicted based largely on his confession and sentenced to prison. To most people at the time, this seemed normal. Police questioned suspects. Suspects answered questions. Confessions led to convictions. That was how justice worked. Or at least, that was how it was believed to work. But Miranda's lawyers challenged the conviction. They argued that the confession was not truly voluntary because Miranda did not understand his constitutional rights. They pointed to the Fifth Amendment, which protects individuals from being compelled to incriminate themselves. The question was no longer about guilt or innocence. It became a deeper question about power, pressure, and the meaning of constitutional rights during police interrogation. This issue wasn't isolated to Arizona. Across the country, police departments routinely interrogated suspects without informing them of their rights. Some interrogations were aggressive, others were subtle, but the imbalance of power was always there. Police were trained professionals. Suspects were often scared, confused, uneducated in the law, or simply overwhelmed by the situation. The Supreme Court agreed to hear Miranda's case along with several similar cases from other states. What the court was really examining was not just one confession, but an entire system of policing and interrogation that had gone largely unquestioned for decades. At the heart of the case was a simple but uncomfortable reality. Most people do not know their constitutional rights unless they are explicitly told. And when someone is in custody, facing authority figures, the pressure to speak can be overwhelming. Silence feels risky. Cooperation feels safer. That psychological pressure is real, even without physical force. The government argued that Miranda's confession was voluntary because there was no evidence of physical coercion. No beating, no threats, no torture. But the court was forced to confront a more modern understanding of coercion. Psychological pressure, the court recognized, can be just as powerful as physical force. This is where Miranda versus Arizona becomes deeply relevant to everyday American life. The case forced the nation to ask whether constitutional rights are meaningful if people don't know they have them. A right you don't understand, or don't know exists, is a right you cannot realistically exercise. The court examined police manuals, interrogation techniques, and standard practices across the country. What they found was revealing. Interrogations were designed to elicit confessions, not to inform suspects of their rights. Officers were trained to keep suspects talking, to downplay the seriousness of the situation, and to discourage requests for legal counsel. This wasn't necessarily done out of malice. It was done because the system rewarded confessions. Confessions closed cases. Confessions led to convictions. Confessions made careers. But the Constitution was not written to make law enforcement easier. It was written to protect individual liberty, especially when the power of the state is at its strongest. For lawyers and legal professionals, Miranda versus Arizona represents a shift from outcome-based justice to process-based justice. The court was saying that how evidence is obtained matters just as much as what the evidence is. A confession extracted without respect for constitutional safeguards is not a victory for justice, even if the suspect is guilty. For ordinary Americans, the case carries an even more practical lesson. Encounters with police are stressful. Words spoken in those moments can follow you for the rest of your life. Miranda recognized that reality and placed a constitutional obligation on the state to level the playing field, at least minimally. This case also highlights an important truth about American law. Constitutional protections evolve through real conflicts, not abstract theories. The Fifth Amendment existed long before Miranda. But it took this case to define how that protection applies in the modern world of professional policing. As policing continues to evolve, with body cameras, recorded interrogations, and public scrutiny, Miranda versus Arizona remains a foundational reference point. Courts still analyze whether statements were made knowingly, intelligently, and voluntarily. Lawyers still challenge confessions based on Miranda violations. Judges still suppress evidence when those rights are ignored. And this is not just a criminal defense issue. Prosecutors rely on Miranda compliance to protect convictions from being overturned. Law enforcement agencies train officers carefully on Miranda warnings to avoid legal disaster. In that sense, Miranda protects the system as much as it protects suspects. This is why the case still matters today, regardless of politics or public opinion. Whether under Democratic or Republican administrations, including during Donald Trump's presidency, Miranda rights remained firmly embedded in American law enforcement practice. No serious administration has attempted to undo them, because they are now seen as a baseline requirement for constitutional policing. What began as one man's confession in a Phoenix interrogation room became a nationwide rule that every American hears the moment they are taken into custody. The words may sound routine now, but they exist because the Supreme Court decided that constitutional rights must be spoken out loud, not assumed. And here's the uncomfortable question this case leaves us with. How many people before Miranda confessed without understanding their rights, simply because no one thought to tell them? That question sets the stage for what the Supreme Court ultimately decided, how the Miranda warning was born, and why its impact reaches far beyond criminal law into the heart of American liberty. By the time Miranda versus Arizona reached the United States Supreme Court, the justices understood they were not just reviewing a confession. They were being asked to define the rules of engagement between the individual and the state at one of the most vulnerable moments in a person's life. Custodial interrogation. The court began with a hard truth that many legal systems had avoided admitting. Custodial police interrogation is inherently coercive. Even without physical abuse, the environment itself creates pressure. A suspect is isolated, confronted by authority, uncertain about what will happen next, and often unaware of their legal options. The court recognized that this imbalance of power matters. The Fifth Amendment does not simply prohibit forced confessions. It protects against compelled self-incrimination. The key word is compelled. The justices made clear that compulsion does not require violence. Psychological pressure, implied consequences, and the strategic structure of interrogation can all compel speech. What the court asked was deceptively simple. How can a person exercise the right to remain silent if they are never told that right exists? How can a waiver of rights be considered knowing and intelligent if the person does not understand the consequences of speaking? The government argued that confessions had been admitted for decades under a totality of the circumstances test. Judges looked at each case and decided whether a confession appeared voluntary. But the court found this approach inadequate. It placed too much faith in after-the-fact judicial review and too little protection at the moment when the constitutional violation actually occurs. The Supreme Court concluded that the Fifth Amendment requires clear procedural safeguards before custodial interrogation begins. Not suggestions. Not guidelines. Requirements. From that reasoning came one of the most recognizable legal statements in American history. Before questioning, police must inform a suspect that they have the right to remain silent, that anything they say can be used against them in court, that they have the right to consult with an attorney and to have that attorney present during questioning, and that if they cannot afford an attorney, one will be appointed for them. These were not symbolic words. The court made it clear that without these warnings, statements obtained during custodial interrogation are presumptively inadmissible. In other words, the price of ignoring these rights is losing the evidence entirely. For legal professionals, this was a radical shift. The court was no longer trusting the system to correct abuses later. It was forcing the system to prevent them up front. The Miranda warning did something else that was just as important. It transferred power back to the individual. It told suspects in plain language that they have choices. They can speak. They can stay silent. They can ask for a lawyer. And once they invoke those rights, questioning must stop. This was not anti-police. The court explicitly stated that effective law enforcement and constitutional protections are not mutually exclusive. Police are still free to question suspects, but they must do so in a way that respects constitutional boundaries. The immediate reaction to the decision was intense. Many law enforcement officials predicted chaos. They warned that criminals would walk free, that confessions would disappear, that policing would become impossible. None of that happened. Instead, police departments adapted. Training programs were updated. Interrogations became more structured. Warnings became routine. And confessions continued, just under clearer constitutional rules. For prosecutors, Miranda became a safeguard. A properly Mirandized confession is far more resilient in court. It reduces appeals. It strengthens convictions. It protects cases from being overturned years later. For defense attorneys, Miranda became a frontline defense. Not because it automatically frees defendants, but because it forces accountability. It ensures that constitutional violations have consequences. The court also clarified something crucial. Miranda rights are not self-executing. They must be invoked. Silence alone is not enough. The suspect must clearly assert the right to remain silent or request an attorney. Once invoked, interrogation must cease. This aspect of Miranda continues to shape litigation today. Courts regularly analyze whether a suspect's invocation was clear, whether questioning truly stopped, and whether subsequent statements were the product of a valid waiver. The decision also reshaped public understanding of the law. For the first time, constitutional rights were being communicated directly to ordinary citizens in moments of crisis. Miranda warnings became a form of civic education, repeated thousands of times every day across the country. Over time, the warning became so familiar that many people forgot its origin. It started to sound like a formality, but in reality, it represents one of the strongest affirmations of individual liberty in modern American law. Miranda versus Arizona also marked a broader shift in the Supreme Court's criminal procedure jurisprudence. The court was signaling that constitutional rights must be practical, not theoretical. A right that exists only on paper is not a right at all. This philosophy influenced later decisions involving search and seizure, right to counsel, and due process protections. Miranda became part of a larger constitutional framework designed to regulate the immense power of the state in criminal investigations. Even decades later, no Supreme Court has overruled Miranda. It has been criticized, limited, and refined, but never abandoned. Conservative and liberal justices alike have recognized that Miranda has become embedded in the fabric of American law. During the Trump administration, as with every modern presidency, Miranda remained untouched. Federal courts continued to enforce it. State courts continued to apply it. Law enforcement agencies continued to train around it. Its endurance is proof that the decision addressed a fundamental issue, not a political trend. Today, Miranda warnings appear in body camera footage, courtroom transcripts, police reports, and everyday conversations. But behind those familiar words is a constitutional principle that still matters deeply. The government must inform you of your rights before it uses your own words against you. And that principle raises a modern question that lawyers, judges, and citizens alike must confront. In an age of digital evidence, recorded interrogations, and public scrutiny, are we truly honoring the spirit of Miranda, or merely reciting its words? That question opens the door to examining how Miranda functions today, where it succeeds, where it fails, and why it remains one of the most litigated and misunderstood doctrines in American criminal law. In the modern United States, Miranda versus Arizona is no longer just a Supreme Court case. It is a daily event. It happens in police stations, on sidewalks, in squad cars, and on body cameras across the country. Yet despite how often Miranda is recited, it is still widely misunderstood, even by people who work within the justice system. One of the biggest misconceptions is that Miranda is required the moment police speak to you. It is not. Miranda applies only when two conditions are met at the same time: custody and interrogation. Miss one, and the warnings are not legally required. That distinction alone explains why Miranda continues to generate litigation decades later. Courts spend enormous time analyzing what custody really means. Is a person free to leave? Would a reasonable person in that situation feel restrained? Traffic stops, voluntary interviews, and brief detentions often fall outside Miranda, even though they feel intimidating to the person involved. This gray area is not accidental. It is where constitutional law meets human psychology. Interrogation also has a specific meaning. It is not casual conversation. It is questioning or conduct designed to elicit an incriminating response. Modern courts examine tone, phrasing, timing, and even silence. A well-trained officer can gather information without technically interrogating, while an untrained one can violate Miranda with a single poorly chosen sentence. For lawyers, this is where Miranda becomes less about memorized warnings and more about strategy. Defense attorneys scrutinize body camera footage frame by frame. Prosecutors analyze waiver language word by word. Judges weigh credibility, context, and constitutional boundaries all at once. Technology has made Miranda more visible but not simpler. Body cameras were supposed to end disputes about what happened during interrogations. Instead, they have exposed how nuanced these interactions really are. A suspect nodding. The pause. A request that sounds ambiguous. Each detail can determine whether a confession survives or collapses in court. Another modern challenge is selective invocation. A suspect may answer some questions but refuse others. The Supreme Court has held that once the right to remain silent or the right to counsel is clearly invoked, questioning must stop. But what counts as clear remains one of the most contested issues in criminal procedure. Statements like, "I think I need a lawyer," or "maybe I shouldn't talk," often become the center of appellate battles. Courts are forced to decide whether those words are firm invocations or mere expressions of uncertainty. The outcome can determine the fate of an entire case. Miranda also intersects with race, class, and education in ways the court acknowledged but could not fully resolve. Not everyone understands legal language the same way. Not everyone feels equally empowered to assert rights. The warning may be uniform, but its impact is not. This is where Miranda's legacy becomes uncomfortable and honest. The law assumes a rational actor who understands their rights and exercises them clearly. Real life is messy. Stress, fear, exhaustion, and authority all influence human behavior. Miranda offers protection, but it does not eliminate inequality. Despite these limitations, Miranda remains one of the strongest barriers against abusive interrogation practices. It has forced professionalism. It has elevated training standards. It has made coercion riskier and accountability unavoidable. From a law enforcement perspective, Miranda is now part of best practice, not an obstacle. Clear warnings protect officers as much as suspects. They create clean evidence. They reduce suppression hearings. They shield cases from reversal years later. Politically, Miranda has survived every shift. Conservative courts have narrowed it but refused to discard it. Liberal courts have defended it while acknowledging its limits. Even during periods of intense law and order rhetoric, including under President Donald Trump's administration, Miranda remained settled law. That stability matters. It tells us something important about American constitutional culture. Some principles become so foundational that abandoning them would undermine public trust in the system itself. Miranda is one of those principles. For everyday Americans, Miranda represents a quiet promise. The government must tell you the rules before it uses your words against you. That promise is not dramatic. It is not perfect, but it is powerful. For lawyers and legal professionals watching this, Miranda is a reminder that constitutional law lives in details. It is not just about landmark opinions. It is about training, practice, judgment, and restraint. A single interrogation can test the integrity of the entire system. And for those who think Miranda is just something you hear on TV, consider this. The most important words you may ever hear from the government are the ones that tell you that you do not have to speak. That realization raises a question worth discussing. In a time of constant surveillance, digital footprints, and recorded interactions, do Americans truly understand their right to silence, or have we become too comfortable talking ourselves into consequences? If this case made you rethink how power, rights, and law actually work in America, let that thought follow you. Share how you see Miranda playing out today. Ask the hard questions. And stay with this channel as we unpack the cases that quietly shape your life more than any headline ever will.